So State versus Dolan is just another example of bias, and been given a line of cases, uh, short little blurbs, as this one is as well, to fully ingrain in you that bias is perhaps the most fundamental basis of cross-examination. Anytime you have anything that goes to bias, it is going to be very liberally admitted. There are things that there are ways judges can try to cabin cross-examination on bias, but it's going to be the more often the case than not that anything that can any way show the bias of a witness is admissible. So in the Dolan case, you had these two parties who were living together, and they had one child together, and then there was another child from another father in the household, and one of the kids is abused, is assaulted, and of course the mom claims that the defendant is the one who did it. The defendant wants to offer evidence that they're going to be suing, or that there is an ongoing custody battle, but that those things, they weren't filed until after the alleged assault. But they are evidence, though, of a dispute that pre-existed the litigation. And so even though the bias has to exist at the time of the incident in question, it is also the case that 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 the even though the actual lawsuit postdates the event, that the lawsuit is evidence that the bias did go back further. And so just the general proposition from Dolan, those things which show bias are going to be readily admissible.